motions
I'm going to
before?
rule on the motion, but I just didn't know. I know y'all said that council was going to be
I
there.
saw Mr. Marchant going through security this morning.
Okay, well, that's fine, that's fine. Let me get organized up here. Hope everybody had a good evening. You up? One of the first things I wanted to just cover before we start getting into my ruling pertains to the media. And I did look at things, and again, like yesterday, I told you that I wanted to make sure that everybody in the media had looked at my order and that they would abide by it. One of the issues or questions that I keep getting is, can we report contemporaneously, or does the 30-minute delay that is in my order, does that pertain to that? And I thought about it, and I will allow you to report. I don't think I can prevent you from reporting on that. Everything else in the order does stand. I don't think I specifically really addressed that point, but I just wanted to clarify that because I think there's been a lot of questions about that. I am concerned, though, I do not want people coming in and out flurry. I don't need distractions for the jury. Okay? I think that will be the last time that we address anything pertaining to the media. But again, I'm thankful that you're here, and our courts are open to the media. All right. I've spent a considerable amount of time looking at case law, these excellent briefs that have been presented to me, your oral arguments, and I am going to grant the state's motion, amended motion in limine, and I'm going to exclude any reference to child pornography involving the victim, her juvenile daughter, I think it's AMP, or Bradley Post. So I'm going to be excluding that, and that also includes the cross-examination of Mr. Post. I will get into that in a moment. I know that we've talked with counsel as far as your ability to do a proper, and he's going to be coming in for a in-camera hearings shortly. I find that it is not relevant under Rule 401 or 2. This evidence has no tendency to make the existence of any fact that is of consequence to this murder more or less likely. It will not assist the jury at arriving at the truth of this murder. The question is, did the defendant commit this murder? And that's the only issue. The child pornography is not relevant, and even if so, I would exclude it under Rule 403 because the probative value is significantly outweighed by, and I know normally we jump to unfair prejudice, and that is part of it, but I would focus on confusion of the issues and misleading the jury. If at some point it does become relevant, then that certainly could be revisited. And again, even if it were found to be relevant, which I don't think it is, it does not come in pertaining to Post under 608C for bias. I know that y'all, that was your argument. Certainly you're going to be protected in proffering. But Mr. Post, he's going to stand, or he's going to have his day in court, and he's going to have to, but he is not, he's not pled, and he's not been tried yet. He's not a co-defendant. He's not an eyewitness to the actual crime. He basically found the body of his girlfriend, fiance, and he's going to be here testifying under subpoena. And it's my understanding he's testifying to finding the body, reporting the murder, which is corroborated by the 911 phone call, and the investigator. The victim was his girlfriend, and he is a victim of harassment. He does have serious charges against him, but these are pending again, and he's innocent until he's proven guilty, and he will have a trial. Also, The Attorney General's office will handle this trial, not the Greenville Solicitor's office. He's not a cooperating witness. He's not providing any type of inculpatory, I guess, evidence linking the defendant to the crime. So they're not offering him in any way to like I said, to inculpate the defendant and of any type of wrongdoing or indication of guilt. I also looked at the State v. Smith, State v. Mitchell, State v. and I can't pronounce this, Beesry or whatever, Pradubsri. And I don't find that the bias issues that were in those cases are in play here. I also reviewed, I think it's Delaware versus something. I think it's Van something, but thank you. Defense can ask Mr. Post if he has any pending charges, but not go into the specific charges. Certainly on the proffer, there will be certain allowance, but I do have the right to impose a limit on the scope of defense counsel's cross-examination and not violate the confrontation clause. And that would be under the another wonderful hard pronunciation, but the Friedrich, F-R-E-I-T-E-K-H case. Also, it would be consistent with Rule 611A. Okay. And I don't think I have anything else to add to that. Anything from the state?
Nothing from the state, Your Honor. So your wish now is to allow Brad Post to offer his testimony? And for the record, Your Honor, what is the purpose of his proffering? So to allow the defense a cross-examination?
Yeah, and you're going to
you just made.
You're going to ask the questions that you're going to ask. Even though I know that you've indicated that you did not feel that was necessary, but I think that allows them to have cross-examination on that. Counsel for Mr. Post will be here. I will have to, I guess, rule if he does assert the Fifth Amendment, then I'll have to rule at that time under whether or not it's just facially prejudicial to him, or if somehow in a chain of events it could, be something improper to be used, okay? But they still have the right in proffer to ask it to protect the record. Limited. Thanks.
And that's in conjunction with your ruling, Your Honor?
Huh?
Their cross-examination under this proffer still needs to be in conjunction with your ruling?
Well, the proffer, I'm going to allow them to at least ask what he has been arrested for, but that will not be asked to the jury. They can ask him, obviously, that he's here under arrest. When they do the in-camera, or when we do the in-camera, I'm going to have counsel for Mr. Post. I'm just going to ask them to sit over here. Mr. Marchant, you're here.
Morning, Your Honor.
Okay. Do you got your other cohorts?
I'm ready to go.
Okay. Anybody else coming?
Mr. Ariel should be here shortly.
Okay. All right. Well, I guess we just need to wait until he's here. Anything else, Solicitor?
No. Thank you, Your Honor, for that clarification.
Anything from defense? Did y'all?
Not right now, Your Honor.
Okay.
I think Mr. Marchant said we can proceed without Mr. Ariel, if that's okay with Your Honor.
No, that's perfectly fine. I just wanted to be
Looking
sure.
at the timeline, I know the jury will be here at 10, and if we can get through this, hopefully start this trial.
That'd be nice.
You can bring up Mr. Post.
Yes, sir.